I actually don't know if they're bad or not. Is kind of the thing. You know, I didn't pre-watch them. I know pre-watch allegations, but I try not to pre-watch stuff I intend to watch on stream. But given that I did choose them, I want you to choose which one first.
Well, I say we should do the free legal aid to strip Dad of his attorney first.
Yes, okay. There we go. Let it.
Great.
Okay,
Johanna Adam.
God, that hair.
Yeah, that is some wild hair. Holy crap. Okay, let me stop. Background music. I said stop. There we go. Alright, we're ready.
Who's seated behind me.
All right, thank you. Mr. Blumberg, is your client with you in your office there?
No, Judge, he's not. I told him he didn't.
Oh, sorry, I also forgot. Thank you, Archmagos, for joining the droplets. It's appreciated.
Oh, very awesome.
And just in case you didn't hear it earlier, thank you, Artemis, for joining the droplets. Want to make Lawtism bingo, but I'm stuck at work.
Yes, no, actually, chat, what we want to do is, like, we should make a community-made, like, bingo card for Lawtism, so everyone can play bingo during our Lawtism streams. Rigo92, thank you for the 5 gifted memberships. Very based indeed.
Yes.
Yep. Yes. All right. I got it.
He didn't have to be here. This motion has to do with my disqualification. Mr. Dick has also filed a motion. Is he participating today?
I have not seen a motion from Mr. Dick.
Your Honor, that motion was for the PPO.
Alright, yeah, give me a second. I'm gonna go back just a little bit, because you guys don't understand how pissed off this old lawyer is. Because the first question asked, okay, well, where's your client? Because this motion. He's like, my client doesn't need to fucking be here because it has to do with me. And then they mentioned something about the other side filing something as well. Does he have to be here? So this lawyer's already coming in swinging. He's pissed off that this has happened and pissed off that legal aid is being used to try and do this.
Also, we've seen this judge a couple times. Really like this judge overall.
I love this judge.
Mr. Blumberg, is your client with you in your office there?
No, Judge, he's not. I told him he didn't have to be here. This motion has to do with my disqualification. Mr. Dick has also filed a motion. Is he participating today?
I have not seen a motion from Mr. Dick.
Your Honor, that motion was for the PPO. We filed a motion in this divorce case and then the PPO. This hearing is just for the divorce case.
All right. So I have not reviewed anything from Mr. Dick involving these parties that I'm aware of.
Can we not call him Mr. Dick?
All right.
Yeah, that's
the motion to disqualify comes from defendant, so I'll let them go first, and then Mr. Blumberg, I'll give you
all right. So this is a motion to disqualify.
an opportunity to respond. So go ahead.
Basically,
counsel.
trying to get rid of the lawyer.
Thank you, Your Honor. Our motion is based on representation by Mr. Blumberg of Miss Adams in a criminal case approximately 8 years ago. According to the Michigan Rule of Professional Conduct 1.9a, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client unless the former client consults after representation. We believe that these matters are substantially related. The courts have used a substantial relationship test, which looks at if there is a close relationship.
So Ava has not seen this, but I do pre-screen things because I'm weird like that. I do.
Well, honestly, it's probably good that somebody does.
Yeah. So not as a spoiler, I just want to bring attention to the fact that she said the two matters are substantially similar.
Yeah. My ears perked up at that as well.
Keep in mind, she says the two matters are substantially similar, and keep in mind we are in family court dealing with custody of the child. Just keep that in mind.
Real quick, while we're paused, I have something to send you, because someone in chat mentioned it. But these actually have already been done, and I'll send it in my chat as well, just via OBS. But someone was asking for this image, and I'm letting chat know that yes, indeed, we have the Phoenix Wright objection image. I haven't done any of the dubbing yet, but we'll do something similar to what Legal Mindset does. But there you guys go. There's the objection image. There's also the one of me holding papers and another one.
Boop. There you go,
here we
chat. Objection.
Objection.
Relationship or likelihood that the confidential information will have relevant to the subsequent representation. And that has been stated by the Attorney General in an opinion attached to our brief from March 28, 1990. And we do believe that there is a likelihood that the confidential information obtained will have relevance, as moral fitness is a best interest of the child factors. And there is a minor child whose custody is at issue in this case. In Mr. Blumberg's brief, his interpretation of the same or substantially related test is counter to case law and a reading of the statute. It does not say anywhere in case law or in the rules of professional conduct that the cases must be virtually identical to be substantially related. And in fact, if that were the case, there would be no reason to include substantially related in the statute. Finally, it does not matter if the information obtained is used or public record, if there was no confidential information retained, or if Mr. Blumberg states he does not remember. The appearance of impropriety is enough. That's true. We believe that this is a big deal, or else we would not be filing a motion. It is just enough that there is even the possibility that Mr. Blumberg has confidential information that he could have obtained from Ms. Adams that could be used against her in this case. Thank you, Your Honor.
Mr. Blumberg.
Judge, I have practiced for 42 years, and I have never seen a case where, first of all, that I've ever been sought to be disqualified, but certainly my representation of Ms. Peak.
Yeah, let's kind of broach that for a second. This dude has been fucking practicing law for the better part of 50 years, has never faced a disqualification motion from opposing counsel. This is extremely rare.
Years ago, in a completely unrelated case, a misdemeanor case that we've destroyed the files. I've not had any recollection of even the events of that case.
So to point out, the case he represented her in was 8 years ago. So it's been a long ass time. Not sure. I don't know if they mentioned the age of the marriage.
And, well, not only that, but it's also, you know, he represented her in a completely unrelated manner in a completely different circuit court, involving a misdemeanor, not family circuit court.
Yes. So the, legal aid is basically trying to argue that because they both involved the mother, that means they're substantially related cases.
That's fucking crazy. That is a reach. This is a very weak argument.
It's really bad.
I have signed an affidavit attesting to the fact that there were no confidential communications that were made to me that I recall. And again, this is her name is attached to the filing, and yet there is no affidavit. There's no assertion of even the nature of the alleged confidential communications. This is a clear case to get me removed so that, in fairness to Ms. Richards, who has not been practicing very long, not to have someone who has been experienced to be representing Mr. Adams in this case. I have a different view, and in our brief, we put into our brief what the test is and what determines a substantial relationship. And I'm quoting right from MRPC 1.9. In deciding whether a substantial relationship exists, the scope and subject of the prior representation and the current representation is reviewed. There is no analysis even applied to this motion that would in any way talk about or compare the prior criminal matter or custodies at issue. Whatever Ms. Peak did or didn't do 8 years ago has no bearing on the best interest factors as it relates to during this marriage. Conduct during the marriage is the analysis for the court in a custody case. Again, I have signed an affidavit attesting to the fact that there are no confidential information that I have or I could be using to prejudice Miss Peak. She simply is trying to exclude me from representing her husband. The fact that she called me after this matter was filed to represent her, and I didn't even take the call. I told her I couldn't talk to her. So clearly they have gone and taken every step imaginable to try to get me disqualified from this case. My client deserves to be represented. I've taken on this case with the understanding that my representation 8 years ago had no bearing. I researched the law before I agreed to take this on. And again, without being disparaging, I think there are some other ulterior motives in the filing of this motion. There is no substantial relationship between this very short-term marriage and a misdemeanor criminal matter from 8 years ago. In a small town where there's so few lawyers, this would be the means to get somebody disqualified at the drop of a hat. And I'm also a bit taken back by the timing of this. I know that when a judge is sought to be disqualified, when there is determined to be a basis to do that, there's 14 days before which you have to file your motion. I'm going to be very delicate in my presentation to the court. I genuinely believe that Ms. Richards has taken this on with the express intent of getting me removed, and I find it to be offensive, and I would ask the court to deny this motion.
All right. Thank you very much, both of you.
That's a pretty solid argument.
Yeah, so I was going to say, what do we think of his presentation so far?
I mean, it's very... It's indicative of somebody who's been practicing law for more than 45 years.
Yes.
I will say that. I'm very much like, yeah, I don't know what wiggle room opposing counsel thinks they have here to justify this kind of a disqualification.
It is quite interesting, kind of the argument they tried to make with this. It's like, okay, yeah, let's go with that,
and I was
guess.
right, by the way. It sounds like this was a short-term marriage, which means less than 5 years.
Yep.
And the potential conflict was from 8 years ago. So this has even less standing than what most people might have thought on the face, which is why I wanted to know how long the marriage had lasted.
Which is a fair question, obviously.
As the party asking for that, is there any final rebuttal that you would like to make at this time?
Yes, Your Honor, thank you. I would just like to state that Miss Adams did not need to show what confidences may have been made, and that would, in fact, be contrary to what we're trying to protect. We're trying to protect her confidences, so forcing her to disclose what she might have said would go against that.
See, that doesn't make any sense. You don't have to tell
the court what you're concerned about. You can't say no. That's the confidences. That, like, we can't say it because that's what we're worried about. Well, you open the fucking door here. We're here. Someone has to hear it. In order to, actually justify and establish that, yeah, it's okay, there's a conflict here. So when you're talking to the judge, no, you can't get to, sorry, can't tell you.
It also just doesn't make sense. It's like, Judge, we can't tell you what he allegedly knows because that would prejudice us. But
that's crazy.
He allegedly knows it already. I thought that's like your whole argument is that
so
he needs to go because he knows
this
information.
Well, we can't say that because it's her secret. It's her confidences. Well, I'm gonna hurt someone. I'm gonna hurt somebody with the law if we don't start making sense.
Yeah. It's like, hon, this is cope. You know it's cope. I know it's cope.
Oh no, my Chad. Why did you do this, guys? I'm never gonna unsee it. That painting picture isn't hanging straight, and I hate it. I also hate it now. Thank you, Chad. I wasn't paying attention to that at first.
Crooked.
Yeah, I fucking hate it. Oh, god damn it, Rigo, thank you for the 5. RKI pleading insanity for his ongoing charges in Korea holds more water than this woman's argument for disqualification. Yeah, and
I don't understand. Why is it crooked?
That plea did not go well. Yeah, why is it crooked? Like,
I don't understand. Why is it crooked?
Like a legal aid office. Oh my god, no. It's worse than that. Look in the corner. we have this weird fucking thing leaning in the corner. There's a painting not hanging on the wall, just leaned up against the wall below the window. This is a mess of a house.
This whole thing is annoying.
Yeah,
It's upsetting me.
I'm now actually enraged.
Fuck you, chat.
Let's be simple. Yeah, chat, why did you have to point this out? I hate it so much.
And the case law supports that she does not need to show that there were confidences that were disclosed. The mere possibility that there were is enough to disclose him. I also find it extremely offensive that Mr. Blumberg would outright state that I am trying to get him disqualified because of his experience.
No, like you were onto something with the perception of impropriety is enough to get somebody removed. That is true. However, the idea that there's a possibility that allegedly they might know something prejudicial, so that's enough to disqualify a whole person.
That's the reach. That's the reach. Had they not fucking tried to go there and just like, look, even the appearance of impropriety, you know, it's a weak argument, but it's an argument. It's an argument that he'll have to respond to, but his response is quite literally, there is no appearance of impropriety here because your marriage has lasted for less than 5 years, and my last interaction with the wife in this situation was 8 years ago, prior to the marriage. There's no appearance of impropriety here. So she's definitely showing her hand by giving all these extra arguments and addressing the fact that, oh no, it's not because I think I want him disqualified because he has more experience. It absolutely is. If you didn't believe that was, if that wasn't like actually, the issue at hand here, you want to I wouldn't have addressed that in argument.
Yeah.
Because it reveals that, hey, yeah, it's kind of like the, hey, don't pay attention behind the curtain. No, I'm not nervous. I don't know what you're talking about. As he like lifts up the coffee cup and it's shaking. It's like, no, you can't address that kind of, it's the elephant in the room. And it's better to honestly kind of ignore the elephant in the room rather than to, no, that elephant isn't there. I know what you're talking about as you point to it.
Elephants aren't real. What are you talking about?
Yeah. Yeah, gaslighting isn't real. You made it up because you're fucking crazy.
File for the express purpose and the only purpose because we believe that there is a conflict of interest that puts my client at risk of having confidences disclosed to Mr. Blumberg being used against her. I find it extremely offensive that he would think that I would file a motion of this severity for pretextual reasons.
Offensive.
And
I find your offense
I would just like to state firmly that this motion is filed because we do believe that there is a conflict of interest.
Oh my gosh.
All right, thank you very much.
By the way,
Ms. Richards, what would be the need for me to rule on this motion if there were an agreement that nothing from the criminal case could be used in the divorce case?
I would still ask that Mr. Blumberg withdraw because this would protect not only Miss Adams, but Mr. Adams as well. The moral fitness is a factor in the best interest of the child case. At every custody hearing, do you have a criminal record is a question that would...
Your Honor, getting rid of his attorney is actually in his best interest.
That's crazy. Like, I mean, look, the judge... First of all, we already know where the judge is going to side with this. At least I feel I have a hint based on his question there because he's offering compromises to get this dropped. The fact that he's doing that means that, hey, guess what? You have an uphill battle to do. Regan Richards, what a name. But you have an uphill battle in convincing the judge that it's worth removing the dad's counsel. It's not, and the judge is leaning there. So you're going, I kind of still want him removed because blah, blah, blah. I'm sorry, the judge isn't paying attention, and you're further losing your case.
Yeah, the judge is kind of already established. Like, he kind of thinks you're wrong.
Yeah. But judge, I still want him removed.
There's a question that would be asked. I think it would be, it would disadvantage his client if that question could not be asked. And I don't know if there is a way for that information to be brought up without the potential of confidential information being brought up.
Mr. Blumberg, is it your intention to ask questions as to the moral fitness of the opposite party?
Let me respond to it this way. The moral fitness factor only addresses the morality and the ability to parent the child. It doesn't go into 8 years ago, whatever behavior may have been displayed.
Yeah, this is a stretch as an argument, especially because things like this typically wouldn't be allowed to come in because of rules of evidence. It's like you go in here, you're arguing your case, and you bring up the fact that she was arrested 8 years ago, as a moral argument, right? The judge is gonna shut that down and in fact admonish you because it wasn't allowed to be let in as evidence in the first place. You can't go, hey, this person has done bad before here, so they might do bad again now. You can't do that in court. It's not allowed. So the whole argument falls on its face because the judge would never allow that in the first place.
Yeah. It's
what
wild that she's going with that.
Yeah.
Happens during the marriage, and is there some deficiency in her morality during this 1.5-year marriage? It's not my intent.
Oh my God.
And it is
Okay, so I was saying that fucking less than 5 years. This fucking shit lasted 18 months.
an officer of the court. I don't think I have to bring that up. I think the merits of the case will be made without that factor being considered, or at least through my questioning of that.
So, Mike, thank you for that answer. Let me make sure I have the fine point on it. The question is whether or not there would be any evidence related to the criminal matter that you represented Ms. Adams or Peak on within the divorce case. You're telling me
Guys, that marriage is shorter than my height.
that you don't believe that there is. If we were to sign if I were to sign an order today indicating that that cannot be used, would that
That's
you
okay.
believe would that
That's
be
what I was saying. Typically speaking, when it comes to these concerns, what happens is the judge will sign an order into the rules of evidence that, hey, unless the mom side somehow opens up that door by talking about it themselves, you as opposing counsel, as the dad side, you cannot bring up this particular thing. And that's exactly what I was just saying, and that would be the procedure here, not a motion to disqualify.
disadvantageous to your client's case, or let me put it this way, would you stipulate to such an order being entered?
I would, but what I would not stipulate to is her conduct during the marriage, because that is completely unrelated to what may or may not have happened 8 years ago.
All right, and what you're telling me is that your professional relationship with her was 8 years ago, and it was not recently during the marriage. Is that correct?
Right.
All right, so the only issue that we're arguing over is whether or not the criminal case 8 years ago would be substantially, or would have a substantial relationship to the divorce case now. And your understanding is that the only substantial relationship that could be made in this case is based on the actions of the criminal case, and you're saying that that's not going to be used in the divorce case as far as you're concerned.
Now, again, my rather vague recollections of that case is that it had nothing to do with domestic violence, which is the issue in the current divorce by virtue of the personal protection order. So I'm not trying to...
That was a very... Look, I wouldn't put on my boxing gloves with this lawyer. I just would. This legal aid lawyer is fucking insane for trying this move.
It's very funny, though.
Evade answering your question, and maybe I didn't, but they are completely unrelated.
All right.
So now we have domestic abuse.
Ms. Richards, if the court were to enter an order that says that the issue of the criminal case 8 years ago cannot be brought into the divorce case, is there then any further need for a decision on disqualification of Mr. Blumberg?
I do believe there is, Your Honor, yes, because it's not necessarily just...
Take the L! Take the fucking L! Are you kidding me right now? That's crazy. That's actually the... I think there is. Are you... No, like, look, you... Oh, Jesus. And you know what's funny? This would technically be considered a win if this lawyer wasn't fucking retarded. You know, you got the judge to enter an order that whatever happened 8 years ago cannot be brought up as some kind of moral argument about how well she takes care of her kids, and it can't be linked to the marriage. That's awesome. That's a W. Why the fuck are you arguing more?
Yeah.
The facts of the criminal case is potential confidences that...
And you're just going to repeat the same question.
That confidences that could have been made by Miss Peak or Miss Adams to Mr. Blumberg. Further, Mr. Adams has already brought up the criminal case in his custody paperwork, showing that he intends to... He at least before retaining Mr. Blumberg, intended to use it. And the case law is very, very clear on the fact that even if there is the potential appearance of impropriety, it warrants disqualification, because this is a very serious issue, and it may not be as...
Also, I'm getting really annoyed at this lady in the background. I know that's the mom, but dear God, she has the body language of a 7-year-old child.
Also, my chat is trying to get in on annoying me like your chat is, and they have chatted that her glasses are also crooked.
Damn it! As soon as you said chat was trying, I'm like, what else could it possibly... Oh my God, her glasses are crooked. Yeah, no, you know what, chat? I'm gonna make it worse for everybody as well. Check out where the crown molding happens, meets the ceiling and the wall. It's not lined up.
Oh, it's bowing out.
Yep, there you go. Let's just make it worse for everyone.
See, it may be just one issue in this case. However, cases set precedents, and what may not be one issue in this case could then be an issue in the next case. And I believe that this issue is such an important...
What next case? No. You case by case basis. You do your best to fucking try these things in a vacuum. So what the fuck
Your
are
Honor,
you talking
don't
about?
understand. This could be worse later,
For
possibly,
the next case.
allegedly.
Hold on, chat. I have a clip for you guys. I'm giving them the objection, Your Honor.
Allegedly, possibly, sometime in the future, this could be a problem.
Is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Overruled. Good call.
Issue that it warrants a strict reading of the rules of professional conduct and disqualification.
What is the next case that you're referring to?
Just not necessarily the next case, but if this case sets a precedent that
why would this case set a precedent?
It just eliminating
this circuit, this level of court does not set precedent. What the fuck are you talking about?
At this point, I think the judge might just be getting confused with her. Like, what the fuck do you mean?
Yeah, that's... sheesh.
What precedent do you think I'm setting?
Yeah, there's... Yeah, that's, on this level of the court system, precedent is not set. That's set at the appellant level and above, typically. Oh, you want to go full OCD? Not only is that painting crooked, it isn't centered on the wall panel. Oh, fuck you. I hate everything about this room now.
One issue could
fix your
resolve this conflict, then another case down the line could also not disqualify an attorney in a situation where there is a conflict.
Well, I appreciate the fact that you think that I set precedent, but I
strongly believe that this is a very, very important issue, and as attorneys, we have a very serious job and we have a lot of responsibilities, and maintaining client confidences is such a big deal, and I believe that is why I filed this motion. I understand that.
So chat.
I appreciate you think I have the power to do that.
Or whatever, some mango juice. And I showed him, because, like, what the hell are you talking about? Because we're going off about the room, right? And I'm like, so Papa Elfpire used to be, like, a carpenter and stuff like that. I'm like, well, here, check out this legal aid family court room. And I just showed it to him. He literally shook his head, looked away, and immediately rushed out of the room. I'm pretty sure I made him physically sick.
Well, because once you start looking at problems, you're like, oh,
yeah, it's so much. It's so much. By the way, I love the fact that there's clearly like a coat rack or something, but it's facing all away.
Oh my god.
This is an extremely serious motion.
It's just so weird.
And I believe strongly that
so
maintaining
weird.
client confidence is an important part of our job. We have a lot of power, and it's important that we don't abuse that power.
All right.
And
it's not your job to
again,
maintain your
by the way,
client
chat?
confidence.
I can't emphasize enough how offended I am by this. To assert in some general way,
Mr. Blumberg, I got you. Mr. Blumberg, I absolutely understand, and I took that very seriously from you. I also take the same statements from Ms. Richards very, very clearly, very seriously as well. So I got that. So let me walk myself through this process of ferreting out where we're at and what we're doing. I am referring to a case that's unpublished, but I think it states the law very clearly, and it helps my analysis. So I'll state it on the record what I'm looking at. This is Morgan versus Ford Motor Company. It's the Court of Appeals docket 3.
Oh, Morgan v. Ford. And there it is, Court of Appeals. Because again, this level does not set precedent. I don't know what the fuck that lawyer was talking about.
362-260 from August 17th of 2023. It is an unpublished case, but as I reviewed the motions and the filings of today's thing, it appears to state it is one of the most up-to-date statements of the law that I could find. So therefore, I'm going to use that in my analysis. It says that a party seeking the disqualification of counsel bears the burden of demonstrating specifically how and as to what issues in the case the likelihood of prejudice will result, and that's from Killingbeck versus Killingbeck, 269 Mishap from 2005. And says that the existence of a conflict of interest that disqualifies counsel is a factual question. The court then goes on to state the rule of professional conduct 1.9, as has been addressed by both of counsel in this case, that says addresses conflicts of interest that arise when an attorney's representation of one client is adverse to another or former client. Under subsection 1.9, subsection A, a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter to which that person's interests are materially adverse.
So that means, like, if he had represented the mom in another family law case, or even maybe a DV case or something like that, right? There might be some weight to this argument. But the fact is, we're in two completely different court circuits and timelines where his professional relationship with this woman had ended 8 years ago in fucking criminal court over a misdemeanor. We are now in family court, dealing with your marriage of a year and a half. I'm sorry, but no, there's no relation to these cases.
I would also point out that legal aid has not actually provided anything that really matters. Because it's one thing to make this argument,
too, because the burden of proof is on the individual filing the motion to disqualify. So you have to show me why you feel like this is an inappropriate relationship and why we should disqualify them. They have not done any of that.
Yeah, all they've really said is he represented her once. Okay, that's not what the rule says.
Yeah.
I think
the rule says you need to be prejudiced against them.
Yeah, exactly. I mean, hey, at least it's not as crazy as, hey, I saw you at that swingers club with a judge.
The parties in a divorce case are materially adverse to each other.
Can you guys do the pause challenge? No.
What's the pause challenge?
I appreciate the follow. It says if someone says pause, you can't move until someone says unpause. If someone says mute, you can't talk until someone says unmute.
Okay, so here's a problem with that, chat. My rigging has base breathing on. Look, I will not move.
And most people's rigging does.
Yeah, see that? See, I can't not move because I'm always moving. I'm like a shark that way.
To each other, their interests
Also, we have a
are
show to do.
materially adverse. So the question, in this case, it's clear that the previous representation was not the same as this one. So the question becomes whether or not they are substantially related matters.
But that's really important, right? It's not just related, substantially related. Words matter in court, and to have the word substantially qualifying related, yeah, I'm sorry, it's got to be a lot closer than 8 years apart over a fucking marriage that ended and started a year and a half ago.
The court, in the case that I'm referencing, says that the attorney breaches his or her fiduciary duty to a former client only by undertaking representation of a client who has interests both adverse and substantially related to the work that the attorney performed for the former client. A lawyer who recurrently handled a type of problem for a former client is not precluded from later representing another client in a wholly distinct problem of that type, even though the subsequent representation involves a position adverse to the prior client. In other words, all subsequent representations of a adverse client are not indicated by the rule. It only is where there's a substantial relationship between the two things that the rule would be applicable. And there is a three-pronged test to determine whether or not the representation of the adverse party is substantially.
There is, because I swear to God, the law loves their three-pronged fucking test. I swear to God.
Related to the previous representation. The first part of that test is the nature and scope of the prior representation. It appears that the prior representation by Mr. Blumberg of Ms. Adams/Peak was a criminal case, misdemeanor case. I've not been told what the subject matter of that was, but it appears that there was a misdemeanor criminal matter of representation approximately 8 years ago. The second part of the test is the nature of the present lawsuit against the former client, and that is a divorce case.
I do gotta say, I would be lying if I didn't say I'm very curious to know what this misdemeanor was.
Oh yeah, no, it's
which they are not the
interesting.
same. Criminal and divorce matters, and especially where they are separated by 8 years in time, are not always substantially linked. And then the third issue is in the course of the prior representation, whether the client might have disclosed to his attorney confidences which could be relevant to the present action and could be detrimental to the former client. And it appears that the area that would encompass would be the morality and or domestic violence. Those would be the two best interests of the child factors where that might come up. Mr. Blumberg has indicated that he is not aware of the previous matter, the criminal matter being involving domestic violence, and that leaves only the morals or the morality factor. And he, again, has indicated he does not believe that they would, as to the time during the divorce, would be related. Ms. Richards, your client has her hand up. You might want to speak with her while I'm doing this. So that's the issue before me, is whether or not
so great. And
under
look, absolutely base judge to not skip a beat. Yeah, your client's hand is up. You might want to talk to them for a second, because I ain't fucking stopping.
Yeah.
That three-part test, the divorce case and the issue of the morality or the morals, the moral fitness would be information available to Mr. Blumberg.
Oh, hold on. Rico92 says, how much you want to bet it was either public intoxication or retail theft? She just has that look about her. I'm thinking it might involve drug possession or something. That's a very common misdemeanor. Well, it's a very common misdemeanor to have, and it would be something that as like if I knew that about my client, and that's the issue at hand from 8 years ago, I do not want any kind of thing like that coming into this custody hearing. And
Fair.
I would be extremely motivated to make sure that can't come in. Now, obviously, this attorney overplayed her and insisting, no, the rules of evidence order isn't enough. It has to be full disqualification. So that's just her being dumb. But I can see someone panicking in a way because, oh shit, my client's got a fucking drug-related offense and we're about to go over morality in a custody case.
Yeah.
That would be, yeah.
In the divorce case, and whether or not there would be an appearance of impropriety from that would allow me to, or would require me to find that he should be disqualified. Ms. Richards is correct that there is a presumption that an attorney receives confidential communications in the course of representing his client. But this court case that I'm citing, Morgan versus Ford Motor Company, also notes that, however, mere disclosure of confidential information to counsel in the course of the prior representation is not itself sufficient grounds for disqualification of that counsel when he later represents an adverse party, because there may not be that substantial relationship test. I am of the mind that if I were to enter an order forbidding Mr. Blumberg from bringing up the fact of the prior criminal case, because the criminal case preceded the time period of the marriage and therefore precedes the divorce issues of custody and parenting time, that should satisfy this matter, because there would be no substantial relationship between the two cases, and therefore no additional issues of the appearance of impropriety to be brought out. And so I'm going to enter an order that allows Mr. Blumberg to remain within the case, but he would be limited in his argument and in his factual assertions to not include anything that has to do with the criminal case that was
once a part of,
the representation that he had of Ms. Peak/Adams 8 years ago. If any of that information does come up or come out, then I would allow Ms. Richards to renew her motion for disqualification, and I would likely disqualify Mr. Blumberg at that time. The reason I'm doing so is because I don't believe that there is a substantial relationship between the two cases with that proviso in.
Yeah, no, if you put that line there, it's like, okay, I don't think there's any kind of substantial relationship here between these two cases or anything, but I'm gonna lay down this line, and if you cross it, that means that there obviously was, and I'm gonna have to disqualify you. It's a very fair ruling from the judge, but it does put Boomer Lawyer into like a little bit, well, that's kind of fucking, he's more limited than he would have been without this attempt.
Yeah.
In place. And I also believe that Mr. Adams has the right to and the need to have good, experienced counsel of his choice. And I believe that is a proper interest to protect as well, especially in a small town where it's not always available to you because of the lack of a large amount of attorneys.
Big city lawyer.
So the court will enter an order of its own. I'll draft that order. And is there anything else that we need to do today, Ms. Richards?
Nothing from us, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
All right. That's all for today then. Thank you very much.
And there
Thank
it
you, Your
is.
Honor.
Always a little less explosive when both sides have representation. But
it's just so funny to me, like the argument she tried to go with.
I have an earnings $1,000 this year, and for.
Hold on, sorry.
Remember, chat. These were Ava's choices.
These were. Is this a bad one? You keep ventilating that. Because you said you pre-watched. I think this is a bad one.
No, I'm just messing with you. I like to give you shit.
I have an earnings of $15,000 this year, and for $1,782 coming out in child support, that's more than my checks would be. That's more than I made for the year. And my son has been living with me pretty much all summer, and he moved in full time last week.
Previously, a DCF case. We had entered our appearance on this on July of 2024, but Megan had contacted.
Look at Megan.
Yes.
And look at that. I mean, I don't.
What's the problem, Ava?
It's in my.
Not being judgy, are you?
No, look, I'm putting it on HD. She has eyebrows, right?
Yes.
Okay.
Contacted DCF to make sure she could switch from DCF to the court trustee in order to pursue a contempt. They, I think, verbally advised her that she could switch, but I do not see that they had filed anything with the court. But at this point, I think we are good to go forward. Obviously, all parties of record get notice, but that's where we're at with that. I just wanted to make that announcement.
I show your entry of appearance on July 19th of 2024. The affidavit and motion for contempt, August 26th of 2024.
Oh.
The sheriff's return. They had no service, sent it out again.
By the way, did I at least do a good job in that we don't have, like, those super stupid, imposing subtitles, emoticons, or exclamations? Because I skipped around a little bit and I didn't notice it. Okay, cool. Because I mean, sometimes it's alright, most times it's just annoying.
And we got a return on it that they were able to serve the defendant on September 30th. And the defendant does appear here today. So, Mr. Jeffrey Brown, any objection to the process?
Yes, no. I object.
Aye. Ms. Grabby, as per your motion for contempt,
I feel like
proceed. Thank you, Your Honor. I just want to give a little history on this case. Normally, obviously, our office does not file contempts when we have a payor making payments. But in this case, we have some special circumstances, and we have a custodial parent who is considering using state resources for medical assistance and potentially for income-based housing. This child also has some special medical needs. My understanding is there is a brain condition, a brain disease that requires additional medical that has to be spent. This case, when I looked through it, the last order modifying support was in February of 2023. And you had already issued income withholding orders on this for the current amounts due, which is $1,372 per month, along with an arrears amount. Jesus. So there's a good IWO with current and arrears, and you.
I'm sorry. Yes. That's okay. I just gotta.
Come on, Ava, what's your problem?
Chat. This is actually something that one might do while listening to this as opposing counsel. Let's just do this. He's fucking adjusted for a full year of pay amounts to $21,384 when he brings home 15 grand. I'm sorry, we got a problem here.
Had 411 for the arrears amount. That was issued both in May and in June of this year. But at this point, we don't have an employer. I believe the payor used to be in the oil field. I don't know if he is still in the oil field. The last employer we had notified us he was no longer there. So if there is a good employer to send an income withholding order, that's what we would prefer to do. But the issue is, I think that we really don't have
look, I'm not trying to be mean, but Tat keeps making really funny comments. She's sporting the Megaton hairstyle from Fallout 4. Or how about this one? Wait, where's the other one? Holy Beehive Batman. is that a small fox sleeping on her head? Personally, guys, I think that, like, this is her normal color up here, but, like, there's some kind of mold that started taking over from the bottom up, and it's just slowly spreading.
Dealer payments being made. And that has been an issue, it looks like, for a couple of years. Just for some history, I have, in August, we had around $1,100 paid. In September, we had around $1,100 paid. In October, so far, we've got $527. And there's 2 months in 2024 where we had no payments. 2 months that were only $400. We had 1 month with $100. So I think it's a little bit sporadic, and it's difficult for Ms. Brown to obviously budget and support the child based on that. So we're really looking for
good
something,
argument.
Hopefully an employer we can send an income withholding order to, so we can start getting those regular payments. But in the absence of an employer, in order to make those payments in full, on time, and to address the arrears per the IWO you've already issued.
How's that going to happen?
Brown.
Yes. Okay, now on all these here, I still was employed at Murphy Drilling through over 3.5 years at Murphy Drilling. I can't control when and where that rig works, and the rig has been down, but I got documents all right here of every pay stub this whole year. The only 1 month that was missing, and that was in June when the rig was down. We don't get paid when the rig's down. I have an earnings of $15,000 this year, and for $1,782 coming out in child support, that's more than my checks would be. That's more than I made for the year. I did fill in while the rig was down at this place called TMAC, but they only wanted me to fill in for a period of time. So I have 3 paycheck stubs here, and I had told them right away about garnishments on that. So I have all the documents of where I worked at and paycheck stubs for it all. It's just the rig has not been working, so therefore I can't make the payment in full for that amount. And my son has been living with me pretty much all summer, and he moved.
Ava, you really need to get a body and face language expert on. Okay, guys, look. I am fascinated by the science of microexpressions and body language, but understand it's a fledgling science, and it's almost on the edge of a pseudoscience. You know, I mean, some people have managed to build a career, 15, 20 years off of being pretty good on this. But there's also just as many institutions that sell themselves as body language experts that get it wrong. So you have to be really careful when looking at body language, facial tics, expressions, micro-expressions, and all that.
In full time last week.
Probably on the same tier as, what do you call it? Lie detector tests.
I would say it's almost a little more informed than a lie detector test, but I mean, you're pretty much still, it's not going to tell you anything more than, okay, this person is a little more nervous than they were a second ago. But it doesn't tell you why. It does, that's where the psychology of interrogation comes from. This is a good tool set to use to get a baseline or a foundation to kind of go hunting for whatever you're looking for, right? But, like, you can't, like, oh, your face ticked this way, you're lying, go to jail. No, I'm sorry, that's not how it works.
Yeah.
No. Mr. Brown, have you notified anyone of your decrease in employment?
No, I have not. I didn't know.
And that's a problem, because if nobody knows you're earning less, nobody knows that you're unable to make your payments, and your payments are due each and every month.
Mm-hmm.
Okay. So you got to communicate.
The trustee explains why they filed contempt even though there are some payments, because they're sporadic and the custodial parent may need state help for medical needs and housing.
Okay. Now, who we get a hold of?
Well, you're gonna need to get a hold of Miss Grabby.
Miss Grabby. Okay.
You're gonna need to get her all of your payment stubs.
Okay.
Okay. You're gonna have to get her at least your last 2 years of your taxes, your tax return, so that she can see your last 2 years plus your pay stubs this year.
Okay.
then you're going to need to file a motion if you want reconsideration of your child support obligation. Because as of now, you're ordered to pay the full amount each month, and that's causing you a great arrearage. Okay?
So yeah, I can get her address and stuff and get this sent off to her, a copy of all this. And the rig has been so unsteady that I did switch jobs first time here. So I had just left Mirthman this week and I started at MommaOcco. I got an address here if you would like it. It is 100 South Main, Suite 310, Wichita, Kansas, 67202. And a phone number for them is 316-264-2314, or 2814, sorry.
And MUD is MUD, right? MUD.
Yeah, MUD-CO.
So I'll send that income withholding out to that employer as well. And then I can send him some documents with regard to letting you know, Jeffrey, what we would need to take a look, which Judge kind of already said, but there's a couple documents you have to fill out. I would be interested in hearing from Ms. Brown, because if we also have a custody issue, obviously our office does not do that. So
are you wanting me to talk about that, Julie?
Judge, is it okay if I question her about that?
Yes.
Okay, so I assume what Jeffrey was talking about was Trenton.
Yes.
Yeah, he's the oldest. He'll turn 18 in July.
I don't care. I don't care if you heard the brain rot words. Do not fucking repeat that arrangement of numbers, I swear.
Okay, so Trenton is turning 18. Is he still going to high school?
Yeah, and VOTEC.
High school and VOTEC. So has he graduated high school?
No, he's doing
Dual program.
Dual program, yeah.
Got it.
Oh.
So he will be graduating high school in May of 2025.
Yes.
Okay. So if we do not have an extension on that, Judge, I would also probably file an extension for that. But what is your you obviously heard the testimony of Mr. Brown. Is that, do you agree that that is the custody arrangement?
What do you mean?
It's not the custody arrangement, but we kind of just let him go back and forth kind of like at his free will, because he's been staying like working on during the week, and so he'll want to go home and see his dad, and I've never denied him from letting him go visit his dad for a few days. Or he just brought up to me that he wants to spend like a week with his dad and then a week with me, and to go back and forth. But that's all. I mean,
that's
hang on, Mr. Brown, you can't speak over the witness, okay? We're recording this.
I'm sorry.
We can only have one person talking at a time, or it's very hard to make a transcript of it if that becomes necessary.
Yes, sir.
So wait till Miss Grabby finishes her discussion with Miss Brown.
Okay.
Now, all of this so far is informal. Nobody is under oath yet. So if you need me to place her under oath, we can do that.
Yes, please.
Yeah, let's
really
just go ahead and do it, Judge.
Setup. I really don't like this. Guy's by himself. He's kind of getting railroaded right now, at least from what I've seen.
Yeah. I mean, that's how it is, though. That's why you really need to bring in a lawyer.
Guys, this is the reason why I fucking quit.
Yeah.
Because it's like this is just so much where it's like, yeah, this guy's I made 15 grand last year. I can't make those payments. You're ordered to pay in full. Where the fuck do you want me to get the money?
Yeah.
Okay. Miss Megan Brown, would you raise your right hand, please? You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
yes.
Thank you. And you're currently in the state of Kansas.
Correct.
Thank you. Go ahead, Miss Grabby.
Thank you, Your Honor. Sorry, eFlex just kind of kicked me out here, so I'm trying to get back in. What are your current custody orders by the court?
They are with me and then every other weekend with their dad. And then we do switch off holidays depending on like what year it is and what holiday.
Okay, and you had
like
indicated that right now, since he's almost 18, basically he goes back and forth and is basically splitting time with both of you.
Yeah, pretty much. We kind of like it was kind of agreed upon, you know, that he could just go back and forth. He drive, you know, since he drives now, and when he's not working, he does like to go see his dad.
Yeah, so here's kind of a thing. Custody gets a lot more dicey the second the kid turns above 15. 16 to 17 years old especially, the kid has a lot of agency on which parent that they're going to choose with, unless there's some extraordinary circumstance like, no, your dad's a registered sex offender, you can't hang out with him, you know, there's unless it's something like that. No, typically speaking, a 16, 17-year-old, they're going to get to choose the conditions of whose roof they're living under and when.
Yeah, because they're at the point where they can...
Exactly.
They're little adults.
Exactly. So with the 70-30 split between the mom and the dad, I'm guessing it's probably closer to 70% of time is being spent with the dad, 30% with the mom, if not less.
Yeah.
And so it's not like...
Would you guys say you're doing a shared custody functionally with Trenton?
Yeah, you are.
I would say yes.
Just a minute, Mr. Brown. You'll get your opportunity. Hold on.
Because up and just till recently, he was at my house every day except for on the weekends. He would leave like on Friday and come back on Sunday night or even
now. Yeah, now he's expressing more of a wanting to do a week-to-week thing.
This is the judge's main point. You didn't notify anyone.
God damn it.
Jeffrey admits he didn't report the income drop, and the judge basically says that's exactly why he's in trouble.
He told me week to week. I'm not sure what he's told his father. He has spent the last couple of days he spent the night at his dad's.
How long has this been going on? Like, is this new?
Like a week, maybe two.
Okay.
Very new.
Okay. The other child living with you as residential parent and going back and forth every other
weekend. And usually if she doesn't want to, he doesn't normally make her go. So she just stays with me.
And if Mr. Brown wanted a modification based on his employment, do you have any objections to that?
Wow, holy shit.
I mean, he owes a...
That tells you all you really need to know.
Yeah, that was holy shit. Like, guys, someone mentioned asking for a body language expert. We don't need one. I want to play that back just real quick because holy shit. That was like, girl, are you possessed by Satan?
She just stays with me.
And if
what's this?
Mr. Brown wanted a modification based on his employment, do you have any objections to that?
He owes a ton amount in back child support.
So that would not affect the back child support amount owed. I'm talking about.
So if he physically could not pay because he does not have work, would you allow us to change this? No.
Yeah, pretty much. She's fishing for reasons to not want to change how things are currently set up because this bitch is they're in Kansas. What the hell in Kansas costs? Even with medical costs for this kid. I'm sorry, if he's driving himself and shit, I don't know how high his fucking medical costs actually are. They seem to be maybe a little bit overstated. Because I don't see the cost of living for a 17-year-old being $1,700 a month in fucking Kansas.
Yeah, and it also we kind of reach the point in family court a lot of the time where it's like you realize that child support is for the child, not for you to just like live comfortably off your ex for the rest of your life.
I mean, one of my fucking big things, and I would love to see more of, is like okay, child support's being paid at a certain point, especially when the kid's like, say, 16, 17 years old. Honestly, there should be an account made in that kid's name that, of course, the parents have control of. Kids are still super stupid when it comes to, spending money and stuff like that. But there needs to be some kind of setup to where the stupid parents who tend to live off of the child support and not give the child the money that's coming in for them, there needs to be some kind of balance there. And I think some kind of like child support account that's paid into that the child has limited access to would maybe circumvent some of the issues with fraud and abuse that happens with child support.
So this may come off a little bit like aggressive, I guess, but I think more places need a rule where if there are kind of disagreements over child support, the person who is receiving the child support needs to be able to provide like some evidence of what they've actually spent it on.
Yeah, no, I agree 100%.
Because if you put forth
with
like
certain
that you
questions
spent
get
like
raised and stuff like that, you can get that, and you can be like, where the court will look at and like, you know what, we need to look into what you're spending this child support on. But again, that's only when certain questions get raised and because the courts are reactionary, something that has already had to have happened before the courts are going to start asking for that information.
Yeah. I feel like there needs to be like some level of default. You have to provide this.
Yeah, I agree. I agree. There needs to be some kind of like you need. Look, you're getting paid shitloads of money every month. That money's supposed to go towards the child's care. I think that at bare minimum, it's your duty of responsibility to, keep up a list of what you purchase with that money and send it in every month. I mean, just as he has to send in that payment every month, I think you sending, a basic list of what you spent over the month for the kid is reasonable.
Yeah.
You're not working for that money. So, I mean, come on.
Just talking about just going forward. Do you have any objections to doing a modification going forward?
And I fucking hate alimony, by the way.
Okay, I don't know is a perfectly fine answer. Okay.
I don't know.
Okay.
When was the last time it was modified? In 23?
Yeah, it was less than a year ago.
And the modification hasn't even been followed, so.
What a bitch.
Do you feel like his employment situation has changed since?
Yeah, no, and what's super annoying is she is going to be using her child's increased independence and autonomy to assert that, well, the modification hasn't been followed, so I don't see a reason why we give him any more custody time and all, whatever, as it reflects on the courts. But it's like, you know what? Kid's old enough right now, this is what's happening, and for you to use his independence and his, who he wants to hang out with more, to be like, oh, well, punish the dad for, being a good dad, kind of thing. It's just really gross. Sorry, it pisses me off.
December of 23?
Oh, no, she's an awful mother.
I feel like it changes all the time.
Oh.
Like, he doesn't work, and then with the rig, he does work, and then he doesn't work. So nothing's ever steady, or he started at this place for a little while, or he's worked for this farmer for a little while, or he's.
Yeah, because you're in fucking rural Kansas. You think jobs grow on fucking trees? Honestly, I'm surprised. Jesus.
This doesn't really work as an argument. It makes more sense if oh no, he's he never has a job, and then he'll have one for a month, and then he'll not have another job for weeks and weeks. No, he is constantly finding work. Anywhere he can, he is finding work.
And picking up what he can, but what you guys are asking of him is not something that's in his earning ability. So I this needs to be looked at by a higher court or another judge or something, because I'm really especially not liking that the judge is just letting this happening and admonishing the dad. who seems to me, he seems to be doing his best. You know, he's not combative. He's interrupted a couple times, but he's been immensely, contrite when that's happened. I don't see,
And I don't think he's doing it on purpose. I think he's...
No, he's not.
Because a lot of people don't realize this in court, that you're not supposed to say shit a lot of the time. He comes across to me as somebody that's just like, oh, I have to respond to this.
Exactly. Especially the 2 times that he's responded, it's when Miss Grab here, or Miss Grabber, whatever her name is, asked Megan a question, and then Megan just didn't answer for like 3 seconds. And so he goes to talk, and is like, hey, stop talking. He's like, yeah, okay. Can we get her to answer in a timely manner, though? This is getting ridiculous. Like, I understand why he's making these mistakes. Rico, thank you for the 5. Again, another 5. Thank you so much. This woman's reaction tells you everything you need to know about her. And this is why my aunt got out of family. It's why most family lawyers will get out of family law. It's soul draining.
Yeah, it's also well, because we're talking about how they won't say anything for a while, and he kind of chimes in to answer. A lot of people who have never been in court before don't realize that when there's witness testimony, and the judge asks a question that seems like a general question anyone could answer, they really just mean lawyer and witness.
Yeah.
They don't actually mean the whole room. So it's fair for people to make these mistakes, because most people don't spend a bunch of time in court, and he is clearly pro se in here.
Oh, this is a decent one. Feral Gaming says, I'd mandate step cards. All purchases tracked with receipts to transaction history so the mom isn't abusing the program.
Yeah.
Like an EBT card, but like a child support card. I really fucking like that.
Sparky says oil rig work has been down from 2023 to 2025. 75% of the workforce has been cut so far.
Oh, this poor guy. This dude's an industry worker who's just being phased out of his fucking job.
Yeah.
Fuck.
So there's a good chance he's probably affected by that.
So it's hard to follow.
Time.
Okay.
And I
think that's all I have for her. If I could maybe ask Mr. Brown some follow-up questions.
Okay, just a minute. Mr. Jeffrey Brown, do you have any questions of Miss Megan Brown?
I don't know what I can really say on this.
I'm asking you if you have questions of her first.
Okay, not anything that I can.
Yeah, this is where I'd love to insert a deposit that one female judge who walks these people through what's happening. Okay, sir, this is your time to ask responding questions. Those questions that you had, maybe there was something that Grab asked that was wrong, but this is where you cross-examine Megan. And explain it to him briefly, and it's fine, and go on. Not I don't know, this judge is coming across to me as a little condescending.
Yeah. The guy clearly doesn't know what he needs to do.
Yeah, which, again, it's a fine line. I get judges that have to walk, but, give him a little more. Throw him a bone, please.
With Miss Gravity here on? No, I don't with Megan right this moment.
Okay.
That I can think of.
Then Mr. Jeffrey Brown, if you'll raise your right hand. Subject to the penalties for perjury in the state of Kansas.
Yes, sir.
And looks like you're in the courthouse here.
Yes.
Okay. Go ahead, Miss Grabby.
Okay, Mr. Brown, I just have a couple questions about what we already talked about. So the first one, you agree that Trenton's not going to graduate till May of 2025?
Yes.
Okay. And we talked a little bit about custody. Would you agree that the custody orders that the court put in place are as what Ms. Brown said, that it's residential with her, but he goes back and forth every weekend? The orders, that's what they say?
The orders.
Okay. And tell me your perspective on what is occurring now.
Okay. Trenton has been pretty much from all this year, every weekend he's at my house. And if he don't have school, he's at my house. And he wants to live full time at my house and go to Hayes to school. And he comes home, the only time he'll stay at his mom's is if he has to go to work that night, where he ain't driving late at night to drive all the way back home. And he's been doing this all year. And I had him.
Yeah, your mom is fucked here. Mom is fucked here.
If Dad had a lawyer, Mom would be fucked.
Yeah, no, that's the issue. Mom should be fucked here, but she's probably not gonna be, and that really annoys me. But the fact of the matter is, like, clearly, Megan, your home is not no home at all. It's a locker room that he only uses when he needs to.
Yeah.
I mean, come on, that should tell you everything you need to know.
All summer long, and Michaela had talked about doing week on, week off shared custody, so that way she could stay between both parents' house and still go to school there in Hayes.
So you're saying for the last year he's been at your house more than every weekend?
Pretty much. Very seldom does he stay at his mom's.
Where does he go to school?
In Hayes.
Are you in Waukene?
Yeah.
So on school nights he's at your house?
Yes. He has been here.
So most weeks during the last year for school, he's been at your house.
Oh man, look
school
at her.
Nights.
I'm so.
She is floundering.
She's starting to have a fucking seizure. Like her, she's gonna start foaming at the mouth, and the zombie virus begins with this bitch. Because holy shit.
Well,
no.
Look, the lawyer's kind of floundering too. Now she's asked the same question 3 times.
Yeah, no.
This would be I mean, if Dad had an attorney, he'd be like, asked and answered, Your Honor. What the fuck are we doing?
Yeah, that's the thing. There's several objections here that I could have made. In fact, I think even the commentator, the person who puts this on, actually put it up right here about the hearsay objection. Because he is saying, oh, this is what, the kid wants. But the kid's not here. The guardian ad litem isn't here. No one is here to actually confirm that was actually said. It's an out-of-court statement asserted for the truth of the matter. So that's technically hearsay, but this also isn't a custody hearing, so...
It's not a custody hearing, and she technically opened up the door when she asked.
Because she's the one asking the question.
But I think the lawyer's having more objection issues right now.
Yeah, no. For 100, honestly, it'd be great to see her go, objection, that you asked the question. Shit.
Yeah.
Just started that here last week, staying full time at my house. But throughout the summer, when no school was going on, and pretty much all weekends, every weekend, we have him, and I would come back and get him, or Michaela, or he would bring her. But then, now with I'm working in Hayes, we're leaving Trent's vehicle here, and we're transporting back and forth. So they will go to school in Hayes and finish their time out at Hayes.
Okay. So the during the week stuff during school, that's kind of a new thing the last week or two.
Yes.
It's kind of the same as Megan said. Okay. Very good. All right. Other than MudCo, do you have any other employers right now?
I would tell Megan to spit that fucking gum out.
Yeah.
Sorry, oh god, it's just fucking, what are you, a cow? Chewing on your chuck? Get the fuck out of here.
Chat asked, why is the disparity in counsel allowed? Basically, just because it's not criminal. If it's not criminal, you don't have a right to counsel.
Yeah, it's a common, you're not always, you don't always have a right to an attorney. It's really only under certain circumstances, and usually criminal circumstances, that you have a right to an attorney. When it comes to civil proceedings, family court, stuff like that, you ain't got that right. Now, there's still legal aid available, and there's options for you, but you don't have a right.
No.
Yeah.
She had mentioned Farman, TMAC, and stuff like that. TMAC was a fill-in when the rig was shut down. Oil is not very good right now, so there's not very many companies. I've been doing this since I was 18 years old. So it is like it was in the 80s in the crash. But TMAC was just something I filled in when they had availability.
That was not good to hear. The last time the oil industry was this bad off was in the 80s during the freaking oil crash. That's when they were rationing fucking gas and shit. That's an industry expert to me, and to hear them say that is a little concerning to me. I'm sorry.
To do it. It wasn't a full-time job. It was just something to do that paid. And
Is
then
MudCo full time?
yes, MommaOcco's full time and going to be a career from here on out. As a truck driver.
Then the employment picture gets clearer. He says T-Mac was temporary and MommaOcco is full-time and supposed to be steady now as a truck driver. Megan adds another twist about their younger child.
And the foreman hasn't been there. I haven't farmed since 2020, 2021, somewhere in there.
And when, I think you said, but when did you say you're starting with MudCo? Was that?
I started this week.
This week. Okay.
For the end of last week there. So.
Okay. I don't think I have any other questions for Mr. Brown, Your Honor.
Hey, Miss Megan Brown, do you have any questions of Mr. Brown?
I don't think so. Other than just Michaela's, I think she just says that she doesn't want to stay at his house. It's too far away, too far out in the country, to not be able to be with her friends in the evening.
This has nothing to do with anything.
Yeah, no. And again, this isn't a custody hearing. Although I will say this much. This is typically what ends up happening in a family unit like this. If there's a daughter usually ends up with the mom. If there's a son will usually end up with the dad. And if not, they'll grow up enough to start hanging out with the dad more than the mom. So this is kind of setting up a preamble to what would likely be split custody. Jeffrey Brown getting the son probably full-time under, his son's full, consent. He's the one who wants to do it. Where the younger daughter might, end up just staying with Megan. Now, that won't be decided today in this hearing, but this could end up coming up in that custody hearing in the future.
Yeah.
That she expresses to me something different than she expresses to him. But she don't want to tell him to hurt his feelings because she just tells me all the time, I don't want to go there.
Which he did as well, by the way, but this would be a time to object to hearsay.
None, Your Honor.
Also objection relevancy.
Objection relevancy, yeah.
Suggestion? Ms. Gray?
So, Your Honor, based on this, I'd like to issue that income withholding order to the new employer. Obviously, I can also send out an EVL and see what he's making, but I can send him modification paperwork. If the Mud Company trucking is going to be the full-time plan from now on, that would be a little more steady. So I would like to start there. Obviously, if Mr. Brown gets oil field, if it starts up and he goes back into oil field, I would expect that he try to make payments towards that $1372 with the arrears in there, because we have a significant like $15K arrears amount. With regard to a modification, Your Honor, it seems like it's something I can do, but we have some custody questions, and obviously those modifications are based on where the children are living. It seems like both parties are in agreement that maybe we are sharing custody with Trenton because he's older and is able to kind of go back and forth. But as for Michaela, like at this point, our office's position is that
not at all.
See, this is a great part where Dad needs a lawyer, because a lawyer would have objected on the basis that she is misstating testimony.
She is. She absolutely is.
Because that's not what he said. He basically said the kid is almost solely with him, and just goes to others when kind of feels like he has to.
Yeah, I mean, this is... Yeah, I mean, Jesus.
Like, I know it's expensive and it sucks, especially when you're, like, in his case and you don't have work. You've got to, like, fish around, right?
You know what I would do? If...
What?
And, this, like, there would be a lot of push right to this. This is, like, ideal world. But if one parent in any kind of, family law thing has the money, gets a lawyer and does all that, then honestly... one should be provided to the opposing counsel. I mean, opposing party, sorry. Like, and that's again, that's a tit for tat, because again, okay, mom went out and got herself a lawyer. now that leaves the dad at a disadvantage. I think that it's the court's job and obligation to ensure those kind of disadvantages don't disenfranchise people. So that would be my solution to this very clear problem.
I could get on board with that. I think some people, their complaint and their pushback would be like, okay, well then you've basically put couples into a Cold War scenario where one is waiting for the other one to pick up a lawyer so they get a free lawyer.
That is true. Yeah, you'd have to legislate this quite a bit, I think.
Yeah. Even then, I don't think it'd be that much of a problem, because if we did this, obviously the person who gets the free lawyer would be getting a state lawyer, which nothing against state lawyers. However, they're overworked, underpaid, and they have way too many cases on their plate.
It's just so that someone with the knowledge necessary to navigate the courts is present on both sides. If it's not present on one side, it doesn't have to be on the other. But if someone goes out and spends fucking 20, 40 grand on a lawyer, and this guy who's destitute can't do shit about it, I'm sorry. I don't want to fucking kick someone while they're down and then bury them with their own lack of fucking a lawyer.
Actually, I could see a good argument for everybody, for there always being standby counsel for both sides.
Yeah, I think that would be really nice. Like a standby kid, someone who can just step in and, you might want to go somewhere else with that.
Yeah. I think that would cause problems where people would say there's an argument that the lawyer's picking one side over the other, but then just have two standby counsels, I guess.
Yeah, maybe. just a couple referees.
Who are just on the court. They wouldn't necessarily just be on specifically the court's payroll, and that would be their job, to come in 9 to 5, sit in the courtroom and just be standby counsel for everybody.
Did everyone see Lord Miles' video explaining his disappearance? Not a great look for CoffeeZilla. He knew about Lord being detained and only did a tweet about it, no video. It's not his obligation to do a video on whether or not someone's been detained. Do you know the kind of things CoffeeZilla makes? He makes fucking, crypto scam videos. What are you talking about?
I would have to know the context, because I do think there is some degree of people who kind of make exposed content, and then when it happens to somebody they know, oh, we don't talk about that.
Yeah, okay, I guess that's fair, if we're going from that, position.
That's why I said I'd have to know specifically the context of why people think this is a problem.
Yeah, I really gotta know why is this a problem? I mean, it was CoffeeZilla and Lord Miles friends or something like that? And that's why he didn't make a video? Because, I mean, CoffeeZilla was Zilla. If, this is some kind of, I don't know who Lord Miles is, right? But whoever he is, if he was, some kind of crypto bro or any kind of thing, he would kind of immediately hop on covering, oh, guess what? This dude has been covered for, has been captured or, detained for this crime. And he'll actually, gloat about it. He's made videos like that. But if this is a friend of his and he hasn't made a video because of his relationship with him, I see the criticism.
Yeah.
Currently say residential, so we would probably do that based on a residential situation. Also, because this is kind of new with this week on stuff, I don't know what's going to happen with it. We can certainly take a look at it. I do see that this case gets modified about once a year. So, we can do it. But it's obviously going to take us a little bit of time to get the documents from the parties. But in the meantime, I would really, I guess, request that if he can make some payments to make those. I know that it's, I think the purpose of my office, right, is to collect support for the child. The purpose of that is so that we do not have to place parents on any sort of public assistance,
support the mother.
Sort of an issue. Yeah, so if he can do that, I would prefer that happen.
Well, as I understand it, Trenton just turned 17 in July.
He did.
and he won't turn 18 until July of 2025.
July of 25. Okay.
After he graduates high school
Okay.
and trade school. Well, he'll probably still be in trade school.
Yeah.
But he'll graduate high school in May and he'll turn 18 in July.
Then we would not need an extension, Your Honor.
Right. Now, Michaela, it appears that she is 13
Yes.
and she'll be 14 here in, next April.
Oh, that's
Correct.
really disappointing to hear.
Your Honor.
And this is just wild speculation, but how much you want to bet Megan has filled that poor girl's head with basically villainizing her own father to her?
Oh no, 1,000%.
Just saying. Yeah, I know it's I don't have any proof, it's speculation, but I'm telling you, it is so fucking common. You could throw a rock in the dark and hit one of these people if they were all in a room.
Give me 1 second.
Okay.
So they've got her in the wrong category. They've got her in 6 to 11 category.
What the fuck?
And she is
She is in fact 13, so that's the 12 to
13.
15 category.
Mr. Brown.
Yes, sir. Okay, I was wondering if it's possible where we can get a hearing where Michaela can speak out instead of his or her saying through. That way Michaela can speak the truth and see what she wants to do.
Well, you're certainly entitled to file a motion, Mr.
Okay.
Brown, and that can come before the court.
Yeah.
That would be easiest. Jeffrey is 17. Megan is 13. I'm sorry, not Megan. Michaela is 13. And they certainly can speak. They certainly can testify so that we can pin down what the custody arrangement is. But you're representing yourself, and it's incumbent upon you to file that motion if you want that heard.
Okay? I get that, but that sucks.
So if you're wanting to modify,
this is why we need a second lawyer. This is why we need somebody, because like he's right there. He's so close to what he needs to do. He asked the judge the right question, and it's like, but yeah, you're by yourself. You gotta file this motion, blah blah blah. But he knows to get his children in to speak on the record in front of this judge at the very least. I hope to God Kansas doesn't let children testify in open court. Most jurisdictions no longer allow that, but yeah, you need to get, a one-on-one with the judge and these children so the judge can ask a few questions and get a lot more context than all the hearsay we've heard during this hearing. On both sides, to be fair.
Yeah.
Time. Or have the court make findings on what the parenting time is.
Interesting dad says, let's just get the child in here to speak about it, while mom is like, this is what she thinks.
Yeah, no, that's very telling. That is extremely telling.
You need to file that motion and get that before the court.
So
then Jeffrey asks for something big, a hearing where the younger child can speak directly, so the court can pin down what she actually wants.
Can I ask?
Hang on just a second. Mr. Brown, without giving me the numbers, is what you're earning at MommaOcco comparable to what you were earning when you were full-time working in the oil patch?
Okay, Murphin, we were getting paid $28 an hour. They dropped our wages down to $26 an hour, but then they weren't working, throughout this whole time. So MommaOcco is $23 an hour. So it's the best thing I can get closest to it. When I was filling in at TMAC, I was only making $19 an hour.
Okay, so it's better than what he was doing.
And MommaOcco, you've indicated is full-time?
Yes, sir.
Okay. And what documents are you wanting, Miss Grabby, to verify?
Well, we'll have to send the modification paperwork. So we're going to send a DRA. We're going to send the cover sheet. We're going to ask for last 3 paycheck stubs. We're going to ask for 2 years tax return. Same thing we do on mods for everybody.
It's still not enough.
And you'll
I
be
just
doing
did the
that with both
calculations.
Mr.
Yeah.
Brown and Miss Brown? Okay,
Yeah.
that's
You have
coming.
to lower his child support. There's no
Okay.
way he can support this.
Yeah.
So if either party wishes the court to consider either the testimony of the kids or where the kids are actually staying for purposes of child support, that motion needs to get in front of the court. Okay?
Judge, can I ask a question?
Sure.
So as of right now, though, child support until that is done is still at the current amount of the 13.
She really wants that money. She doesn't care what happens going forward so long as that money still comes to her. That's I mean, frankly, if that's your one question here, fucking I got some questions of my own. And you might not like them.
70.
It is at the amount until we have a motion filed. Once the motion's filed and we have a hearing, we can go back to the time of the motion.
Okay.
But there being no motion before the court, the child support is still the $1,372 as of this time.
Okay, that was my
$1,300,
question.
by the way.
Right.
Your Honor.
Yeah.
That will continue on unless and until there's a motion before the court to modify. Mr. Brown.
Where do I go to get a motion filed at?
Well,
You can do it right here in the courthouse, right?
you can look at the Kansas
Directing
Judicial
legal aid.
Kansas Judicial website, and they have pro se forms. Council, that's the word I was looking for. Kansas Judicial Council.
Okay.
So Kansas
That's right, in the
Judicial
courthouse.
Council has some pro se forms that you can look at.
Your Honor, if that does get filed, how would you prefer to do it? Our office typically doesn't get involved in custody matters. Is that a hearing you would have ahead of time, make a determination, and then we would figure child support based on that?
It doesn't matter what your
Well,
office gets
obviously,
involved
we
in.
have
You're
to
involved
know
now.
what the situation
Yeah,
is
you're
as to
here on
whether or
for the
not
ride,
the
dude.
child support has a modification based on a joint residency situation. So I suspect
Why are you
that
asking the
happens,
judge what he wants
that
you
these
to
are
do?
both happening simultaneously,
When our
or
only
should
questions are
happen
about the money should just
fairly
be thrown out.
simultaneously.
I kind of
And
agree, but you
we'll
can't
have
do
to
that.
decide where the kids are
I wish you
staying
could, though.
in order to calculate the
too.
child support. So if the parties have agreement on what the actual custody is, as far as where the children are staying, what percentage of time, and if you two agree, that can be given to Miss Grabby. She can then prepare the proposed child support worksheet and show it to the two of you. If you are agreeable, that's fine. If not, we can have a court hearing.
Oh, Judge, so then he may not have to file that pro se order.
No,
is that
he'll
right?
still need to file the motion or it won't be before the court.
Okay.
You know,
Yeah, they're asking for
Okay.
half of
but
his
part of the
wages.
questionnaire that you're
And child
receiving
support.
from Miss Grabby is where do the children stay, what percent of the time? Okay,
Frankly,
Okay.
ridiculous amount.
and you've
Yeah,
got
it's
117
insane.
and 113.
But you have two
I'm sure
kids,
she'll
so that
wanna
makes
say
it a
and a
little more
half.
Understandable.
So
Yeah.
Still, I don't think I don't think I'd have to.
so you've got
I don't think it would take $800 a month per kid for me to raise children in Kansas.
Yeah.
Like,
I mean, it's
we
fucking
have to
Kansas,
remember
bro.
where we are and where. Yeah, like if I was in Cali, New York, or one of the more expensive states, yeah. Honestly, I'm surprised there's not more at that point. But this is freaking Kansas. They're like in the top 10 poorest states in the nation.
Like, what are you spending this money on exactly?
Yeah, exactly.
I'm just about to turn 14. Okay. So if the parties are in agreement with that, so be it. If you're not, make
Child
sure you
support,
get
your kids
that
don't
on
like you
file,
anyway.
Mr. Brown, and we'll
Okay.
look at all of it.
I got one other question.
But to answer Miss Grabby's, you can certainly sit in, Miss Grabby, while we decide that. You don't have to, but if you sit in and hear the answer, then you can calculate your child support. Yes, Mr. Brown.
Okay, I didn't know if I could possibly find out exactly kind of where the child support split between the two kids for the amount. What is Trenton's and what is Michaela's?
Yeah, I can go over the worksheet with you.
Important.
Okay.
You can go over the worksheet with you. I've got it in front of me. Basically, right now, it's based on Michaela being 6 to 11 years of age, and that's
gonna need a
737.
Damn.
Definitely.
I'm not gonna lie. Even though even though I've never stepped foot in Kansas, I was goddamn almost right on the money on where the split was.
Yeah.
It was $700-800. Yeah. That's fucking crazy.
And Trenton, 12 to 18 being $784. But then there's some deductions that come out of that, which take it down to the 1372.
Okay, well, since it's wrong on the age, 6 to 11, and she's 13, that's 2 years that it's been wrong. What does that do?
I'm not saying 2 years it's wrong. I'm saying it's based on that because this was done in 2022.
Okay.
She was 11.
Okay.
She jumped to 12 shortly after the worksheet. Again, it was not brought to the court's attention, so nothing has changed.
Okay.
So,
Jeffrey, I'll have
it's
my
fucked
assistant
over
give
that.
you a call to schedule time. Megan, do you want me to do the same?
Yeah.
Okay. So I can answer any questions that I can
Does
answer for you
Costco
guys,
down
and
as
kind
they
of I
get
can go through the
older?
worksheet.
It depends on the state, but typically yes. 6 to 11 is probably the highest amount in child support that you would pay because the kid's fucking growing like a goddamn weed. You have to replace shoes, clothes, all kinds of stuff all the time. Lots of expenses between 6 to 11 years old. Not so much between 12 and 17. So I imagine that it would be the cost would go down at least a little bit. Maybe only $20, but $20 is $20.
It's with you. Explain kind of
Yes, I did. Yes, I did that on purpose.
the process a little more.
Okay, sounds great.
Chat, $20 is $20.
okay.
Miss
$20
Gabby,
is
do you have my
$20,
number
man.
where they can contact me?
I have a number. I don't know if it's the right number.
What I will do, we're about to wrap up. I'll jump off, but you guys don't.
Okay.
Stay on. Once I jump off, we'll stop broadcasting. And then you can give Miss Grabby that contact information without broadcasting it out, okay?
Thank you.
That's good.
And that way
Fucking
everybody
hate her
has
name, by the
everybody's
way.
numbers, both phone number and emails,
Is she sweating?
so that you can get the paperwork back and forth, okay?
Okay.
She's fucking sweat. Look, her face is shining.
Anything else for today's hearing?
Nothing for me, Your Honor.
Okay. So, Mr. Brown, you understand that your obligation is still in place unless and until you file a motion and the court changes that child support obligation.
Yes.
Okay. Ms. Grabby, you'll do the order?
I'll do the order, Your Honor.
Okay. I'm going to jump off, and then you guys can exchange your information, okay?
Sounds good.
Thank you all.
Thank you.
Remember, put the needs of those kiddos first in your discussions back and forth, okay?
Sure.
Thank you.
Perfect.
Thank you.
Well, there that one is.
Yeah. Something
Yeah,
tells
that
me
one
their
wasn't very,
discussions are not going to go great.
No, I can't. I mean, there's so much there that
The son falls into the older category.
Whoa.
Then deductions bring it back down to the ordered amount. The judge reminds both parents. Exchange
You just gotta
contact
pause it.
info private.
Oh, it's
no,
just
keep still
paused.
going.
It's
Contact
just like,
info
it's still
privately.
going. It's just doing,
Keep support current unless changed by
Oh, they're just doing a dumb recap. Nobody cares.
Yeah. Nobody cares,
cares.
nerd. Freaking nerd.
I'd care if you were speaking it yourself, but
Yeah,
you
yeah,
AI
yeah,
voiceover.
but that's not. Yeah, AI auto dub or whatever the hell. Come on.
No more AI voiceover. They're dumb.
Come on. Yeah, I heard, like, it's funny, one of my favorite AI voice, there's only a couple channels that I like. Watop is one of them. And I didn't
Who?
actually even know,
Watop.
Yeah, WhatsApp, I think it's called. Oh, thank you so much, Cerberus, for the 20. Yo, you can't be paying me money. I want to pay you money to commission your art. What the fuck? $20 is $20. Thank you for the 20. Even if it's burning a hole in your pocket, get this to give them head pats. That's $20 head pat, Mizu. Get it on this.
I'm head patting.
All right.
We had pat.
Thank you so much, Cerberus, for the 20. But seriously, I want to commission you. Stop paying me.
Oh, isn't Ava sweet, chat? Just a good bean.
I try to be a good bean.
But
chat... But that's just to draw you in so I can get your blood, so...
We know. Dirty bloodsucker.
Damn right. What's up? Alright, Chad, I think that's all we had today. It's a little bit of a shorter episode, which is fine.
Yes, chat, I apologize still. I'm still a bit under the weather. Trust me, I've been really enjoying...
with Vegeta. I'm surprised you're not... You know, you're still breathing, so... Guys, it was crazy.
I'm just that good.
Yeah, he topped Vegeta. You know how hard that is?
It was actually pretty easy.
Oh, damn.
Skill issue for other people, honestly.
Yeah, no, that dad is definitely... Chad's talking about the dad. Like, I feel sad for the dad. Yeah, he's got an uphill battle. I feel very bad for him. But luckily, you know, already, because it's 2026 now, at least one of the kids is no longer, you know, under the age of 18 and therefore having to be a part of that child support calculation. So right now, as of right now, if nothing changed, his child support is currently half of what it was when this hearing went down. So
yeah, he's probably not as in bad of shape as he was.
Yeah. But alright, chat, thank you so much for coming out, hanging out with us for the last couple hours. Don't forget to like, comment, subscribe, hit the notification bell as hard as you possibly can, and we will, of course, see you all on the next one while I rapidly figure out where we're rating you guys into.
Yeah, I'm just gonna let Ava handle all that. She's going down the list. There might be something more tonight, chat. I'm not making promises, though, because I'm not sure just yet. But if there is, I will notify you, beautiful peoples.
Alright, direct. Let's see. Archcast, Selby, Doki Bird, Penumbra. Why am I subscribed to Penumbra?
Also, sorry, really quick. Artemis for 5. Maybe we're too used to lame duck judges that don't keep their court in line, but now it seems like he's going to give out contempt charges for heavy breathing.
Yeah, no, for real. Like, it seemed... he seemed a little more of a hard ass of a judge than, like... what we're used to seeing, I guess.
Yeah, I like our other judges.
Yeah,
oh, Doki Bird is streaming. I'm just gonna rate into Doki Bird. I like Doki Bird.
Perfect. I'm rating into Archcast.
Archcast?
So I will see y'all later, chat.
Where's Arch streaming? Maybe I rate into Arch because...
You should.
We just double rate into it.
Get double rated.
Oh, he's doing Valkyria Chronicles 4.
Okay. Perfect.